Good evening, all of you. Welcome to the refresher course on GUJRERA practice and professional opportunities. Before we jump upon the session, I request the organizer to please play ICM motto.
य एष सुप्तेषु जाग्रति य एष सुप्तेषु जाग्रति कामं 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 कामपुरुषो पुरुषो निर्मिमाणः निर्मिमाणः तदेव शुक्रं तद्ब्रह्मा तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यपि कश्चन एतद्द्वैता 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 एतद्द्वैता.
Welcome back to the session of refresher course on GUJRERA practice and professional opportunities. I welcome the chairman of WSYCI, C. Manish Gadia ji, faculties of this refresher course, C. Ramesh Prabhuji and C. Vinay Thyagaraj ji, the co-editors Aditya Maheshwari ji, Advocate Mithil Vinod Sampat ji, C. Kaushik Sampat ji faculty, and my council colleague C. Vikas Jain. Welcome all of you to the refresher course. Before I talk about the technical aspects of this particular course, I think this opportunity cannot be missed by everyone, every member of the region. That is what the chairman of WSICI is today having a birthday. And on behalf of everyone, all the members of the region and all participants, sir, we wish you happiest birthday. And in this occasion, sir, I would like to say that we all want you to prosper ahead and ahead, and we want a person like you to take this profession at the new height. With this brief word, I request the chairman of WSICI, the birthday boy today, to give introduction of the session.
Thank you, Chintan bhai. And I'm really grateful that I have a support of my entire council, and my all council members are really working very, very hard in the interest of the profession. So it's really a great. And today we are discussing Gujarat RERA, going to discuss a refresher course on Gujarat RERA. And again, I'm thankful to CA Ramesh Prabhuji for structuring this entire course. And under his editorship and joint editor Kaushik Sampat ji. Now, in this 30th August, we are going to release a book on RERA, law and practice. And it's, I can say, a Bible of any RERA book which is not available in the market as of now. It will cover entire gamut of related to real estate industry, including not only RERA aspect, but also the GST income tax aspect, whatever we have involved. Even the architect are also contributing as a contributor. So we are covering entire gamut of the real estate industry in this book. And the roughly size of the book will be more than 1500 pages. So you need not require to go anywhere else once you are relating to real estate industry. Vinay Thyagaraj ji, Mithil Sampat, all this, the faculties of this Gujarat RERA is also a contributor in that book. So I'm really, really thankful to Prabhuji and Kaushik Sampat ji for contributing this book, coordinating with this book, and this book we are going to release next week. Apart from that, WRC has taken various initiatives for members in industry. We have taken initiative like CEO Speak, a journey from articleship to CEO. The second session is going to happen on 28th August, that is Saturday morning, 10 to 11, 1 hour. We have also started CFO forum where the members in industry meet, CFO of large corporates and mid corporates meet every month and discuss about their issues. Apart from that, technology, we are invested heavily, and various programs you have seen on technology. I am not going into detail. And again, we have, I will tell about a project called TEL, that is Train, Earn and Learn, where we are giving a training to undergraduate of various colleges so that they can work at the CA office. And after that, we are placing them as a trainee with the CA firm. So in Mumbai, more than 2,000 such undergraduate students are available for training with the CA firm. So those CA firms who are interested can approach WIRC for this. The similar pattern we are going to start in soon in Gujarat. Vikas Bhai, Chintan Bhai is taking lead in that. So soon we will see in Ahmedabad. Rajkot also we are working with the university for this. So Surat also we are working. So you can take, the members can take the benefit of the same. So thank you very much. Over to you, Chintan Bhai.
Thank you so much, Manish Bhai, for sharing the brief about the various initiatives taken by WRC by ICI. And you have partly covered my aspects of introduction faculty, because when you're talking about the booklet, 1,500 pages, you already given the part information of the faculty CA Ramesh Prabhuji. Let me just complete another part which has been left. That is the professional qualification of faculty. He is a fellow member of ICAI with BCom and LLB. Is a founder partner of Mrs. Venu and Vinay, a CA having 20 years of experience in taxation and business consulting. He has chosen and practiced on RERA since 2016. He has presented seminar at various forums on investment, taxation, GST, RERA. He is practicing since so many years and conducting more than 170 workshop webinars across India. He has been a guest speaker at various forums, including colleges, and regular panelist discussions at news channels, TV9, Raj, and other channels. His articles are published at various forums. Along with us, we have another very eminent personality in faculty, who is basically CA Ramesh Prabhuji. I actually discussed about Vinayji. Now I'm talking about CA Ramesh Prabhuji. Ramesh Prabhuji is a Mumbai-based CA with CISA, practicing over last 27 years. He's a partner of Mrs. R.S. Prabhu and Associates, promoter and founder chairman of Swagat Housing Finance Company Limited. Is a regular faculty of ICI regarding real estate and cooperative subjects. He's also addressed a number of seminars organized by government department, newspapers, political parties, NGOs, etc. He is a member of committee constituted by government to amend MCS Act 1960 and Rules 1961. He is a member of committee constituted by government to draft cooperative audit manual. He has a practical, in-depth knowledge of housing sector, author of 40 books on issues like conveyance, transfer of flats, parking, collection of dues for members, and GST for real estate housing society. So there are many things which we need to talk about, and I heartiest welcome both the faculties to this particular forum. And now I request the first faculty, CA Ramesh Prabhuji, to really start the session. Vinayji, I think you can start. Ramesh Prabhuji.
Yes, sir. Chintan, sir, is I'm audible?
Yes, you're audible. Please go on.
Okay, thank you.
I'll just take it. Sorry. Thank you very much. Of course, let me at the outset, wish our chairman, Manish Gadia, for his birthday. And of course, all other faculties, especially Chintan Patel, who is the RCM, and Vikas Jain, for giving us an opportunity to be part of Gujarat RERA also. Vinay, of course, is from Bangalore, but since he is involved in our RERA practice, I thought we also should involve him in Gujarat RERA practice manual also. Then, of course, we have Kaushik Sampat, who has been a co-editor in our new book, RERA, that is Maharashtra Real Estate Regulatory Authority Law and Practice book, where he is a co-editor with me. where we have done a number of books. Thank you very much. And let me now, at the outset, let me tell you, the RERA has been enacted in the year 2016. A year was given to the various state governments to establish regulatory authority as well as appellate tribunal, and of course come out with the rules. Most of the governments have done their job, and only one government, that is West Bengal, they were not taking active part, and rather they went ahead and brought out West Bengal Housing Industry Regulatory Authority or Regulation Act. Now, this particular thing was not required. However, the matter went before the Honorable Supreme Court, and Honorable Supreme Court in the last month was, kind enough, or rather, I would say, they upheld the RERA, and they said West Bengal, what they have done is a separate law is unconstitutional. Similarly, as you know, any law when it emerges, the most affected people will definitely try to raise their voice. And this particular RERA, Real Estate Regulation and Development Act 2016, was enacted to bring the discipline, especially financial discipline and transparency among the real estate sector. And therefore, they were the most affected. One who was scot-free. And if the government is planning to bring some regulatory mechanism, naturally it is going to affect them. And therefore, what they thought that let us go ahead and put the petition in different high courts. Naturally, around 40 petitioners in different high courts moved in the against the constitutional validity of the law. Ultimately, the central government, who had enacted this law under the concurrent list, referred the matter to Supreme Court, and they said it is not possible to go and defend every high court, and it is also possible that there can be contrary judgments, and it is better that the Supreme Court should transfer all the petitions to Supreme Court, and the Supreme Court should hear the matter. You know, whenever there is a big brother, he always likes that it should be done by the smaller brother so that his activity is getting reduced. So the Supreme Court, in their wisdom, decided that let the Bombay High Court decide the matter within 2 months. So the ball was put in the Bombay High Court, and Bombay High Court on day-to-day basis, the hearing was conducted. All the petitioners came, including RERA and other authorities, and of course movement of the people. And after hearing the various parties, the Honorable High Court was Bombay High Court was rather pleased to uphold the constitutional validity of this. And on 6th December 2017, the judgment was delivered. 1st May 2017 is the law. This was enacted somewhere in August. It was transferred to Bombay High Court, and immediately somewhere August, September, it was transferred to Supreme High Court, Bombay, and within 2 months, Bombay High Court passed the order. That is the speed in which this act was taken seriously. If somebody wants to study and really go through the RERA, I would recommend that they should go through Nilkamal Suburban Realtors Private Limited versus Union of India. That is a writ petition 2737 of 2017 of the Bombay High Court. And in this judgment of 330 pages, each of the controversial subject and the sections has been discussed in detail. The pros and cons have been decided. And if somebody is going to practice in RERA, I think he cannot and he should not ignore this judgment. We call this as a celebrity judgment. And in every hearing, one or the other person does refer this judgment. And I can tell you, I have been referring or representing before the appellate tribunal as well as regulatory authority across India, and I have seen everybody has kept this as a Bible in their desk, which means whenever anybody refers, they refer with the paragraph and then they go in. So therefore, my submission is the people should definitely, the people who want to practice should go through this judgment. It is available on the, just Google it, you will get Nilkamal Realtors versus Union of India, writ petition 2737 of 2017. Having said this, now what is this all law about? I have certain issues or the reservation because of my throat infection, and I will be requesting Vinay Thyagaraj to take you through the entire overview of the law. And we at Gujarat also, under the guidance and the support of all the faculties whom we have listed in the refresher course, we are also coming out with a Gujarat RERA law and practice. Almost 7 to 8 chapters have been written by various authors, and we are in the process. All the faculties who are in this refresher course are going to contribute that manual, and as and when that manual is published, I'd request all of you to go through it, purchase it. It will be a great asset. Similarly, Maharashtra, we have already come out with the Maharashtra RERA law and practice. This will be published on 30th of August 2021 in the hands of none other than President of our institute, Niyar Jambusaria, in a function at our own institute building. And once this is published, that will be circulated through Taxman publication. So it will be available across India. I would suggest that one should have the copy of that judgment, that book also, having about 75 chapters and 10 parts, taking care of various segments, which of course our colleague Kaushik Sampat will discuss. And similarly, we will do for Gujarat. So your support is required. With this, thank you very much for giving me this opportunity. And I now request Vinay Thyagaraj to take it forward. And I request Vinay Mishraji to give the scene sharing to Mr. Vinay Thyagaraj. Thank you very much.
Thank you, sir. Thank you, Ramesh Prabhu, sir. Good evening to all the participants. Hope my voice is clear. Sir, PPT, somebody should help me. Which is the button I should click it in terms of show my screen or?
You show.
सर आपका स्क्रीन शेयर है, आपने वो विंडो अपना वर्ड खोल के रखा है,
your screen is already shared, Vinay. You have to simply play the PPT.
Sir, is that visible now?
No, PPT is not visible. Your screen is visible.
Now?
Now it is visible.
No, PPT is there, sir, now?
Yeah, PPT is there. Yeah.
But for me, I am not able to see the PPT. I can see only my picture and your picture. How do I?
No problem. We can see. This is how this webinar is.
Oh, then, but I can't read my screen. So where do I see that? Is that?
That is. You can't see your own PPT.
Yes, sir. So which is the view I should select, sir? Hello. Sir, can I get a view of the PPT?
विनय जी उनको जरा गाइड करिए ना, पीपीटी कैसा वो देख सकते हैं, क्योंकि हम लोग देख रहे हैं. अभी दिखाई दे रहा है आपको?
Yes, sir. I can see that now. Video is not visible. Only the screen I can see. Is that okay?
No problem. Go ahead, sir. We can listen to you properly.
Okay. Thank you so much, sir. Thank you. Very good evening to all. Congratulations for WIRC for hosting one more session on RERA for the Gujarat GUJRERA. Recently, we had a similar session for Maharashtra RERA last month only. In the month of July, I was one of the speaker, and again I'm glad to be part of this session also in the month of August for Gujarat RERA. Having said, as Suresh sir has given, Ramesh Prabhu sir has given the basic information of the how RERA is evolved, and in today's session I will be talking about this topics in the today's session. One is the background of RERA and the journey, objectives of it, overview of the RERA Act, the RERA rules and RERA regulations of Gujarat, and implementation scoreboard of Gujarat RERA, and what would be the probable outcome having implemented the RERA in effective manner. This is the total overall session, so topic for my discussion in today's session, sir. So as we all know that this industry, the real estate industry contributes second largest to our GDP, the employment, and also to the economy. The moment we say that economy, it is not only in terms of the GDP, in terms of the taxation also, the revenue to the government by way of this sector is huge and contribution is huge. And also see that why this law was required is we didn't have the transparency in this business. The standardization across the industry, across the business was missing, and major thing is accountability. How the accountability was missing could be looked at by looking at various provisions of the RERA and how they brought back the accountability in this industry. And what was the challenges we were also facing under this act and prior to the act is the interest of the landowners, the interest of the buyers, the interest of the investors, the interest of the lenders, the government agencies, the vendors, and the professionals were at stake. Even though the second largest industry after agriculture, but in spite of the so big industry, we had a challenges to protect the functionaries and their interest across all. So this act, this statute is given a fair protection to all of these functionaries under the act. Then also what will be the ultimate requirement is overall development in the industry and the confidence with the global investors. And unfortunately, in spite of we say it's the second largest, and attracting the global investment is a challenge under this industry or this sector for the various reasons. Till now, we could not able to make a much impact on attracting the global investors across all type of promoters or the builders. Of course, we have seen various investment on a specific specific companies or a specific SPVs, and most of those investment are through the REIT rather than any other capital infusion or equity into the organization or the industry itself. So this is what was the challenges, and these were the challenges to encounter. And there's a law which has brought in by the government of India, and we see that how the journey is taken place in the subsequent slide. And also if you see that like various industries has their own regulator, and for real estate the RERA is a regulator. And friends, over the period we have seen RERA, it completed its 4 years of its journey, and we are in the 5th year. 2016 they have, 2017 in terms of effective implementation, now we are in 2021. So effectively 4 years functioning of RERA is complete, and we are in the 5th year. And if you see various other industries, other industry regulator like a insurance regulator, telecom regulator, and investment regulator like a SEBI, RBI for a banking, manufacturing and food for some FSSAI, this industry will look into, this industry will have a regulator by RERA. The RERA is authority who regulate this industry. I'm sure that at least another few years, maybe another 5 years or another 10 years, we see this RERA is like regulating like a SEBI or a RBI. And because now whatever be the regulations the authorities are looking at is at the various aspects of the projects which are started very much prior to the RERA, that means before 1/5/2017, and still it is not completed, and which is of the ongoing status. Of course, the new projects also included as part of this, but overall we may see another 5 years or 10 years for us to see the complete and big picture of this statute. Friends, for us to be part of that, we should start practicing from now itself. to see to see and also enjoy the benefits of this practice down the line 5 years. And if you see the RERA, which is effective from 1/5/2017, is just not which is started overnight. And in 2009, when the Parliament was discussing in terms of to bringing some law relating to the real estate sector, that's how the discussion at the Parliament is started. Even though the land related laws are related to the state has a jurisdiction in terms of the land related laws. How the central government can come, how the central government can enact a law which also govern the land related. That's how RERA has come into picture 2009, and where in 2015 the Union Cabinet approved it. 2016 Rajya Sabha also passed it. That's how in Lok Sabha the Real Estate Bill of 2015, assent of the President of India, and wherein from 1/5/2016 69 sections of the RERA is enacted, which comes into force, which is more related to the administrative. It is more related to the state government activities like enactment, like notification of a rules, appointment of an authority, establishment of the establishment of and implementation of the website. So those are all most of administrative. Those are the 69 sections which are enacted and effective from 1/5/2016. However, remaining sections which are most relating to the industry and also where all promoters professions play an important role, that is section 3, 19, 40, 59, 70 and 17 and 80, and notified, and which is effective from 1/5/2017. This is the central act. Central act is it has enacted are effective in the at two levels. One is in 2016, another is in 2017. Similarly, by virtue of this act, central government has given a power to the state government to notify, to draft rules, to draft and notify the rules. Accordingly, state governments have drafted and notified the rules. Accordingly, Gujarat RERA has notified the rules. One is in terms of the RERA Regulatory Authority rules, which is notified on October 29, 2016, and RERA General rules, which is notified on May 4th, 2017. That's how Gujarat RERA rules has been notified, and also which is effective from 4th May 2017. And friends, this is a journey of RERA. You may have, or you may encounter a question from any of the promoter or a builder or a professional stating that RERA has made a big impact, and some may be positive, some may be negative, and also they may say that all of a sudden this has come. We should keep it in the mind, it doesn't come all of a sudden. It has a background, and the entire stakeholders worked about 8 to 9 years to bring this real estate law as into reality. That's how the act and the rules has been traveled from 2009 to 2017. And friends, even though we are in 5th year of the act, 5th year of this enactment of the act, and a few of the participants may be new to it, and you may take up this statute or this as an area of your practice, and for the benefit of the few, for the benefit of those members who are listening or hearing first time of the RERA. So this RERA preamble, as a professionals, as at least as a chartered accountant, generally we start reading any statute with a preamble with an intent to know what is the objective of the act and what this act intend to do it. So similarly, this is a preamble of and objective of the RERA. In summary, the industry require a regulation, and also industry require a promotion. It is not only the regulation, industry also looking for promotion of this industry, promotion of these activities in an efficient manner. That's what is important. What was missing is the efficient in this industry practices. There was a transparency was a big challenge. You all agree that this transparency in the real estate sector, real estate business was a big challenge, and also we are all personally and also professionally experienced on these issues on the transparency. Also, this act provide for interest of the consumer Friends, we all know that any dispute or any conflict of interest between the customer and the builder, we fondly call it as allotee and the promoter under RERA. Throughout the act, it has used the promoter, which includes various the definition of a promoter includes various people, which is maybe a builder, developer, GPA holder, and also anybody who is in the business of the real estate. And maybe the subsequent speakers would discuss in detail about the definition of the promoter. So promoter and the allottees are nothing but the customer or consumer under the act. So to protect the interest of the consumers is the what most important under this act. The reason being, friends, the industry, the business, the speciality of the business is the promoter or the builder starts selling an idea, selling something which doesn't exist at all. What the builder sells is an idea. What a builder sells based on some pictorial representation. He sells his idea by way of a brochure where the product doesn't exist at all. In that situation, how the customer and how the consumer should be protected. So that is utmost important aspects under this. Prior to RERA, the option was available in case of a dispute or a litigation to go under the Consumer Protection Act or under the civil court. So this act gives a special importance, and also which has a mechanism of adjudicating mechanism where the complaints of a promoter and a allottee can be heard. So that means to say this has a inbuilt adjudicating mechanism to redress and to for the purpose of speedy dispute resolution. And that is what is one of the important aspect of it. And also there are something called appeals. The appeal of the adjudicating officer or the authority can be heard at the first appeal. The second appeal would be with the High Court only. With this, the time consumption in case of a litigation, in case of a dispute, would be substantially reduced. I am sure that subsequent speakers of the sessions, either tomorrow or day after, would discuss and deliberate on various aspects of the adjudicating mechanism and also appeal. And also you can see, you can listen from them in terms of the number of days wherein there is a mandatory disposal of the complaint is 60 days. So effectively within 60 days, if anybody file a complaint, either a promoter or a allottee in a project, automatically dispose within 60 days versus the much time taken under Consumer Protection Act or under the civil suit. So this which gives a much protection to both the promoter as well as the consumers. Having said how the objectives are spread across the statute would be presented by way of this page or this presentation. The regulation mechanism is defined between section 3 to 8, which in section 3 to 8 is mostly related to the registration, extension and revocation of the project. That would be in detail would be discussed by other speakers. And also if you see that other regulation which is part of the RERA, including advertisement, how the advertisement should be given, how the promotion should be done, how the marketing should be done, and how the agents, what is the role of an agent, what is the responsibility of agent. Agent include the broker, channel partners, marketing agency, whoever part of the project in terms of promotion, and their roles and responsibilities have been brought in. That means to say the more accountability on everyone whoever involves as a project for the purpose of promotion. And also there are more regulation in terms of modification of the sanction plan. Friends, we all know that once the project approval is taken, project plan sanction is obtained from the development authority or the municipal authority. Prior to the RERA, the promoter used to take or enter into an agreement with a standard note that the promoter has a right to modify without informing, without taking consent from any of the allottees or the consumer. Friends, those privileges are taken out under RERA. Any modification after obtain the RERA approval, then it has to be taken a consent from the allottees. Without that, the law doesn't permit them to go for a modification. First take a consent from the allottees, then come to RERA, file an application and get a approval of the modification. Friends, various states have followed in their own way of regulation for the modification, and please refer to the respective modification module of the Gujarat RERA also. And in terms of transfer of the project, there is a transfer mechanism under the RERA, like section 15 of the act talks about the transfer. The promoter wanted to give up the project to somebody else. He just can't give up himself. There is a mechanism under this where he has to go back to the allottees, convince them, take their consent, come back to the authority, take the consent or approval from the authority for the purpose of transfer of that project. So with this, there is a mechanism in terms of transferring or giving up the project to some other promoter or some other builder or some other entity. So in this way, the authority regulate the entire aspect, entire transactions of the real estate. And also finally, as we all know that this industry has the least discipline in terms of the finance, management of the finance, mean to say that there was a practice under the act, practice prior to the RERA, wherein money has been collected and money has been utilized for something else also apart from the project which has collected. But this act has come very disciplined and very strict in terms of the collections and spending of the money collected for the specific project. And also there are various compliances in terms of quarterly filing, annual audit, and also various mandatory practices under RERA in terms of financial management. So with this, there is a regulation part. We all know that in all aspects, if you ask me how to do the real estate business, means one should read the RERA Act. If somebody trying to do some business without understanding the RERA Act, they would be in a difficult position, or they would be in terms of messing up themselves. That's what is my experience over the 5 years. Unless you follow RERA, you cannot exist in the real estate business. And government is bringing very harsh regulations, and also conveniently, whoever follow the act and the rules, they would be in a safer hand and they're happy in terms of doing their business. And if you ask me, is it so difficult to follow the RERA? Answer is no. Answer is no, because of difficulty in understanding and also finding a very few professionals who are guiding the promoters of the real estate project. That is why everybody experiencing this RERA is very harsh or difficult. Otherwise, what you do is to be captured prior to launch of a project and follow the same. That is what this act and law talks about. And when you follow something, it has to be when you want to do something, it has to be done within the four corners of law itself. That's all. There is no much difficulty in terms of RERA. However, why people facing difficulty is in terms of they trying to understand in a correct manner. So unless it is understood in a correct manner, very difficult for somebody to address to the various challenges under the act. And friends, the act not only talks about regulation, there is a promotion activity. There is a promotional activity, and section 32 of the act has a various functions of the authority for them to promotion this industry, promotion this sector itself. And also the efficiency, we have seen in the preamble of the act, there is efficiency matters. What are the efficiencies? Like a timely delivery of the project is a one utmost important for all the stakeholders, whether it's a builder, whether it's a landowner, whether it's a customer, whether it's a lender, whether it's a vendor, whether it's a investor. Everybody looking at the timely delivery of the project. The moment the real estate project is delivered in time, every stakeholders in the business, every stakeholders in the industry get benefited, including the government agency also. They end up with collecting their dues by way of GST or the income tax or the stamp duty or any other levies of the state. So with this, efficiency is the utmost important, utmost fundamental to this industry, and also very much as part of the act itself. We know that there is a transparency we all experienced it as an individual customer or maybe a professional whenever we deal with the any builder or the real estate promoter. So availability of the information was always a challenge. Collecting of the timely information was a challenge, and also holding them responsible for something was the bigger challenge. With this act, we have crossed the challenge of the transparency, because the information would be available online at all point of time for all the stakeholders, for them to go and pursue it, and also go and download the information which is very much available in the website. And also finally, protection the interest of the consumer by way of adjudicating mechanism, and also appellate, and also, as I mentioned, conciliation of disputes. This is a bigger picture, and whoever talks, whichever be the speaker talks, they talk entire act within this framework of RERA, within this framework of within the framework of this. As I mentioned that it is not only the regulation, there is a development in this. That's why the name talks about as the Real Estate Regulation and Development Act. It is not only the regulation, there is a development. Of course, as I mentioned that authorities, the state authorities, the RERA authorities are in the verge of identifying how they can develop the industry. Now, apart from the regulation, if you see that the various aspects of the regulation, which is including bringing the healthy, transparent, efficient, competitive real estate sector environment, facilitate the growth. We mean to say that authorities are responsible to facilitate the growth of the real estate industry. How it can be facilitated is something they should come out with the various possible opportunities for the industry for them to achieve it. And as I mentioned, that transparent, robust grievance redressal mechanism, there are various redressal mechanism which is including conciliation forums, where they're calling both the promoter, builder, and also a real estate association to reconcile it, and also see to it that grievances are addressed without going into taking into a legal way. And very big important thing is a single window system, single window clearance system in terms of various approvals by this industry. Friends, in my experience over last few years, this industry faces a challenge of various approval to be obtained from various state and central government agencies to get their plan sanction. And after plan sanction also, there are various regulations for them to obtain, for them to go through in terms of the clearances. And this authority has a power to recommend to the central state government to make a single window system for clearance of the file and various approval so that the promoters would be at peace, promoters would execute their project in an efficient and also effective manner and timely manner. Friends, as I mentioned in the earlier slide, one of the important aspect under RERA is delivery of the project in the scheduled time. And by bringing the single window system, I'm sure that authority also can insist upon or impress upon all the builders that the project can be delivered in time. And big role to play by this industry, by this authority, is encourage the investment in the real estate sector. Having brought in the act in place and getting the investment globally into this sector is utmost important, for the simple reason this industry is a capital intensive industry. Money is the big requirement under the act, under the for development of any project. So this authority has a role to play in terms of bringing and encouraging the investment also. And grading of the project, we all know that there are something called ranking and credit rating for any other thing, like section 32 of the act has something like a grading of the project. I remember Uttar Pradesh has come out with a white paper on grading of the project, and where they appointed one of the leading consultants to come out with various parameters for the purpose of grading of project. I'm sure that various state authorities, including the Gujarat RERA, will soon come out with the grading of the project, which will give a benefit to all the stakeholders of the industry, all the functionaries of the industry, either a customer or a lender, whether for a customer to buy based on the grading of the project, or the lenders to lend the money based on the grading of the project, which is one of the development aspect, one of the important aspect of the authority also. Similarly, digitalization of the land records and the system. Friends, we all know that as of now, the land system or land titles are not digitized, which has a very difficult for any buyer to understand the title of it. So with the authority recommending to the state government in terms of facilitation of the digitization of the land record, which gives a big boost, big opportunity for all the stakeholders of the industry to get better share of their pie. And also any other recommendation in terms of the reduction or increase in the GST or the stamp duty in the interest of the industry from time to time. Friends, we all know various states have reduced the stamp duty during last 2 years in order to facilitate, in order to encourage the buyers to buy it. I'm sure that reduction in the stamp duty may not have much benefit to the builder. However, it is a benefit to the customer, where their money where they can save the cost by in terms of reduction in stamp duty. In turn, promoters can liquidate their inventory. This is what is important. It is what is the crux of reduction in the stamp duty. So with these are all the various development activities the authority can look into, rather than looking only on the regulation part of it. All the 4 years what we have seen and what we have observed is a most of a regulatory mechanism they have built in, they brought in. I'm sure that going forward authorities would think on the development aspect also. And as I mentioned, the framework of RERA, it is a central enactment, it's a central act, and act by way of giving the powers to the state. Every state has come out and notified the rules, and Gujarat also notified the rules. Gujarat Real Estate Regulation and Development Rules 2017. By virtue of that, there are various regulations also. Authority has framed the regulation, and which is also notified. And with this, there is a clear framework of act, rules, and the regulation. The regulation cannot override the rules cannot override the act. And with this, the entire framework of RERA is clearly structured such a way that it benefit all the stakeholders. And below are the address of the authority and also the appellate tribunal in the state of Gujarat. Having said that, how Gujarat RERA specifically have framework their functioning or structured their entire activities. Friends, regulatory authority rules which is brought in and notified in the year 2016 October, which gives the bigger picture for how the authority to work, authority to function. And also tribunal rules has been notified by Gujarat RERA. General rules, which is more of a RERA rules, we fondly call it as a RERA rules 2017, Gujarat RERA rules 2017. An agreement of sale is notified by Gujarat RERA. Friends, one of the objective of the RERA is standardization of practices, transparency in practices, accountability in practices. With the notification of the agreement for sale, what does that mean is every promoter of the real estate industry should follow the same format of the agreement for sale. So what does that mean is like it is, so till now we had a agreement for sale which is only a 2 pages, and somebody drafted for 200 pages. So however, under RERA, Gujarat, every state has notified the rules as part of the rules. Also they notified the agreement for sale, format for agreement for sale. Every real estate promoter has to follow the same format of the agreement for sale without much correction into it, without much modification. in case of any modification, that modification should not override or should not dilute the act or rules, objective of the act and rules. So this agreement for sale is a must, and the format of the same shall be used by all the promoters for this project. And RERA regulations, we have seen in the earlier slide various regulations which have brought in by the authority, which is for the purpose of working and also execution of their work. About various regulations or clarifications of various regulation by the Gujarat RERA from time to time. Friends, I will say that Gujarat RERA is a very active in terms of issuing various clarifications, issuance of various notification and formats which is notified by Gujarat RERA from time to time. This gives a relief for the professionals like us to understand the importance and also follow some of the standard practices and procedure and also the formats which are notified by RERA. Friends, it is very few states are actively issuing various notifications, circulars or clarification in nature. Amongst them, Gujarat RERA is one amongst the top after Maharashtra. So they are coming out with a frequent clarification for various challenges which are faced by the industry as well as the professional. This is how the authority gives the benefit to the professionals as well as all the stakeholders. And generally the structure of this authority functions independently under the act and under the rules. This authority is headed by the chairperson, is the retired additional secretary, is a retired, or maybe he may be in a service which not less than the rank of additional secretary to the government. Generally, in my experience, most of the authorities appointed by the state governments are retired IAS officers. Accordingly, Gujarat RERA also has a chairperson, and also we have two members are also of the rank of additional secretary, rank of the additional secretary, and of which generally we have member 1 and member 2, and also below them there is a secretary generally would be deputed by the government, who would be in a service not less than the rank of a state administrative services and maybe equivalent to administrative services also. And below them there would be a various aspects, various sections which is of a technical for the purpose of looking at the various laws relating to the real estate. We have accounts, finance, IT section, legal section, and regulation section. This is how the bigger picture of the organization structure of the Gujarat RERA. Friends, each of this department, each of this section has a role to play when the document or when the application for registration is received. Each of this section would verifying it, validating, and clearing the files. Friends, I just wanted to give you the bigger score, and this is how the Gujarat RERA has achieved. This is the second largest in the country after Maharashtra, and also which has achieved about 8,860. The share of Gujarat RERA across India is about 12 to 13% in the entire India, which stands at second place. And also it's a very good software, very good application the Gujarat RERA has implemented. The website is a very informative and very inputs and very good inputs. And recently I also have heard that Gujarat version 2, Gujarat RERA 2.0 is also launched, and a good initiative, and which also makes our professional services is at our fingertips. This is the various registration which you can see on the website of RERA, and which is also classified based on the district wise and spread across all states, also across districts. This is the grievances. You have about 2,805 complaints which are filed from various districts and based on various projects. As I told you, friends, Gujarat RERA is a front runner in issuing the guidance, issuing the clarification, and very few states have issued a which is unique in nature, of which I appreciate the Gujarat RERA authorities have taken a much pain in terms of issuing these notices, issuing this clarification, and also a circular which gives a much importance, much beneficial to the entire stakeholders of the industry. And I just wanted to share a few of them, including means of finance. Friends, we all know that this industry is a capital intensive, and really we do not know which promoter is capable of executing or completing the project in time. And we only know that these promoters have a good skill of selling it, but ultimately if the sales, if those efforts are not converted into sales, they would have a challenge of generating the cash flow for the purpose of development activities. So this authority, Gujarat RERA, has made it a point, along with the application for registration, they're asking what is the source of funds for the project, that is called means of finance. How much you are relying upon sales collection from the customer, how much is the borrowing, how much you are willing to bring the money into the project as your equity or your contribution. Friends, this is most important. As a professional, we also play a very important role. As a chartered accountant, we play an important role in terms of advising the clients, in terms of preparing a document of means of finance or source of finance to them. So friends, look at this. If you look at the format of it, which is a very enhanced, it is nothing but your projection, like you give it to any banker. Similar way it has been drafted and it has been structured. Also various clarification and the agreement, and which gives a confidence to the various stakeholders or the promoters of the project. And also see the we all know that this Gantt chart and the project schedule, which is more of a statistical in nature, and RERA authority of Gujarat is already brought in terms of these charts also, which gives a pictorial presentation of how the project development is scheduled and how the actual development is completed. Friends, finally, this is my last slide. What would be the outcome the moment we see this the RERA is implemented, and also in an effective manner? And if we all recommend, advise all our promoters, all the stakeholders in a good intention or good way, we can see that there is a improved accountability, improved transparency, bring the professionalism in this industry. We can see the standardization of various practices of the business, and also with this we can bring some of the responsibilities, symmetry of information availability between all the stakeholders, all the functionaries of the project, and we can reduce the dispute amongst various stakeholders. It may be a landowner, or it may be a builder, it may be a developer, it may be a vendor, or it may be a customer at last. So we can bring the dispute in the project, we can bring down the disputes, which reduces the stress on the legal system. We know that how much the legal system and all the courts are stressed up with various cases or the disputes. With this implementation of RERA, I'm sure that other courts would enjoy to the stress to the extent of the litigation under RERA. With all these efforts, we can see a good governance in the sector, a positive industry status, and also international recognition. Friends, in spite of various efforts of all, still this industry doesn't got a industry status from the central government. With that, there are various challenges or various benefits which are lost if you don't get an industry status. I'm sure that with implementation of RERA, at least down the line few years, this industry gets a status of a real industry, real estate industry get a real industry status, which with that various benefits of the government can be reaped into and also make beneficial to various stakeholders. with international recognition, we can expect a good inflow of investment into the industry itself. So with this, I'm concluding my presentation. Thank you so much for your patience hearing, and thank you so much for the opportunity for giving my insight into the objective, that journey and various aspects under RERA. Thank you so much, and thank you to WIRC for the opportunity, sir.
Yeah, thank you, CA Ramesh Prabhu sir and CA Vinay Thyagaraj for the deliberation, so giving us the background journey, objects, and the scoreboard at a glance and overview of RERA. Now I will request CA Vikas Jain, RCM, WRC to kindly give a formal vote of thanks to the speakers.
Thank you very much, Aditya ji. It has been a wonderful deliberation, I would say, from both Ramesh Prabhu sir and Vinay ji. Ramesh ji is always very proactive in our region and has been, I would say, the king of the cooperatives and all this. So whenever the name comes for cooperative, RERA and all these, so we are having only one name with us, and that is Ramesh Prabhu sir. So thank you very much, sir, for the wonderful deliberation and also contributing to the publications and all. Vinay ji, it was a wonderful deliberation and presentation was fantastic, I would say, covering all the aspects, the organogram, and then the various other things. So this has been very lucid and easy to understand for those also who are not into practice of RERA. So sir, would love to have you again on some other day or some other opportunity. Thank you very much for being with us. Thank you for the wonderful deliberation. Thanks a lot, sir.
Thank you, sir.
So thank you, Vikas sir. So moving on to the next topic for the day, it's going to be taken by CA Kaushik Sampat, and the topic is important stakeholders under RERA and contents and structure of Gujarat RERA practice module. So I will request again CA Vikas Jain to introduce Kaushik Sampat sir.
Thank you, Aditya ji, once again. So it's my privilege to introduce another learned faculty for the day, Kaushik Sampat ji. Kaushik sir qualified as a chartered accountant in the year 1986, and he qualified CMA in the year 1991. He has various certifications under his belt that include certified PMP, project management professional, from Project Management Institute of USA in 1999. He is also a certified cost consultant from AACE Institute USA in 2006. Both the institutes are specializing in the project management related field. He has worked in project related entities almost the entire career for about more than 35 years. He commenced his career with the real estate entity in the mid of 1980s. He is also associated with engineering, consultancy and contracting industry for over 30 years. He has worked with various multinational entity. He has worked with multinational entity in the oil and gas industry in Middle East as finance manager for over 20 years. So sir is having vast experience, I would say. In the last 5 years, he has settled back in India and was involved with real estate entities for RERA and all this. Currently, he is working as a freelance consultant with real estate industry. His key skills and interests is in the field of construction, project management, especially real estate in Mumbai. With these brief introduction, I present before you our today's learned speaker, Kaushik Sampat ji. Sir, over to you. Thank you very much for being with us.
Thank you very much for the kind introduction. Also, a warm welcome to all, and hope that all are safe and healthy at home, offices, and around you. The COVID-19 has really ensured that we are probably stuck home for most of the time for the last 18 months, and we're just kind of opening up. So I would like to thank basically the WIRC for arranging this refresher course on RERA. As mentioned by Ramesh Prabhu sir and Vinay, who was the earlier speaker, we had a refresher course on RERA, which was held in July 21. And I think that is what has ensured that we move forward. Ultimately, this is WIRC. We needed to cover Maharashtra. We also needed to cover Gujarat. I'm also happy to note that we have a very reasonably good attendance today. And I'm sure that all the members who are participating, both as a faculty as well as attendees who want to refresh their knowledge or even get into RERA, will benefit out of this. I just need to know whether my screen is visible to all, sir.
Visible.
My screen is visible?
Yes, sir.
Hello. The slide screen is visible, sir?
Yeah, important first title.
Yes. Okay. Yeah. Thank you very much. Ramesh sir, Prabhu sir discussed about the constitutional challenge, and then it was one odd man out, which the state of West Bengal trying to bring in their own regulations, which was actually nullified by the Supreme Court order just about last month. So what we have now is a pan-India law. Vinay discussed the journey of RERA, and that it began in 2008, and then finally it had the presidential assent in 2016 and went into effect from 1st May 2017. Perhaps no other law in India has had such a head start in implementation as RERA. That's because for a long time, most of the stakeholders in the industry knew that such a law is coming. It has been debated, discussed, probably at all levels of the government, as well as with so many other stakeholders. So what came out eventually was a distilled wisdom of all the lawmakers and the stakeholders within the industry. What we are going to now discuss for the next 15-20 minutes is the practice manual. As mentioned by Ramesh sir, practice manual for RERA has already been finalized. In fact, I think he finalized it early this morning. It's going for publication and likely to be released by this month end by the president of ICAI. There was also a simultaneous plan to ensure that we come out with a GUJRERA manual. Now, in terms of what will be in the RERA manual and the GUJRERA manual, I think 80% will be the same. But as Vinay discussed, that GUJRERA has been very proactive. The kind of circulars which they have brought in, the kind of rules and regulations which have been brought in, especially with respect to means of finance, Gantt chart and project schedule is something very unique. So I think we will cover that all into a very short presentation. What I'm going to say is basically it will give an idea to all the attendees as to what to expect from the manual and how it will help them to raise their own level of practice. So we go over to the background and timelines of RERA and GUJRERA. Everybody knows, yes, RERA 2016 went into force from 1st May 2017. There was a constitutional challenge which was disposed of by the Mumbai High Court in December 2017. GUJRERA was established by notification around October 2016. However, around June 2017, the interim regulator was appointed by the government of Gujarat. What happens is when any law comes in or any law which is enacted on a pan-India basis and the states have to take further steps into the implementation, they have to follow a system whereby they come out with the rules, the regulations, they ensure that all the powers have been exercised in the correct sequence. So, one of the things under the RERA itself is how you can appoint the chairperson of the authority. So the chairperson of the authority goes through a selection process, which cannot happen until the real estate regulatory authority itself is established. So there's a sequence of actions which happened, and I think after RERA, GUJRERA was very proactive. They went into action very fast. By May 2017, they came out with the rules, appointment of officers rules, rates of interest, regulations. Again, we'll touch base that framework, and I think Vinay also touched base the framework. Almost I could see 9 line items into how Gujarat RERA has done it. They have even come in with amendment to the rules. That shows the level of proactiveness of GUJRERA. Then, in the first year itself, authority registered 2,200 projects. Now, one of the slides again, which Vinay put up, showed that Gujarat is number 2 after Maharashtra in terms of registration. And honestly, what we saw is that there were around 9,000 projects which are registered as of date, 8,800 something, of which 3,000 have been completed, which means 5,000 are still under execution. And each one of those 5,000 projects requires regular compliances. And Gujarat RERA, again with the quarterly QPR compliances, is again in the forefront. We'll again discuss this later on. One of the things was that initially GUJRERA came out with both physical and online applications for registration. But since December 2018, I think the entire registration has gone through online. So this process is online. And I think the current chairman is now Amarjit Singh, retired IAS. Sorry for the spelling error. I think Gujarat RERA now has a full-time regulator chairman appointed under RERA. Now, this is just a slide which says which were the key contributors for content and review. We started the process around May, but since I think the focus went on RERA manual, we have not been able to take the process forward. But as you can see, there are almost 11 contributories from Gujarat itself. So we expect that the quality of manual will be reasonably of a high standard, and it will help all the CAs practicing or those who intend to practice to get into this kind of practice. Reason being, this sector is expected to really grow. It's one of the second largest contributories to the economy, the construction sector, and within the construction sector is the real estate sector. So we just move on to the next slide. So what are the practice areas? How exactly is a chartered accountant going to look at it? Typically, the scope comes into registration. Yes, almost a whole lot of details go into the registration process itself. Detailed scrutiny happens. I understand that GUJRERA scrutiny is very, very stringent. The quality of documentation which they ask for is also very stringent, and I was told that they even scrutinize and they can even pinpoint errors, if any, into the sanction process. That to me is a very high level of scrutiny. On one hand, it ensures that projects which are registered really are implementable, and they also link into the competent authorities sanction with respect to plans. Next is the certification. RERA puts the onus or takes the help of 3 or 4 professionals in order to register the project. Chartered accountant is one of the key certifying agency. The others being lawyers and architects and engineers. Together, they basically this trinity ensures that Section 42 LD with respect to realization of amounts from allottees and utilization for the project is well handled and well managed, and there is no siphoning of funds or diversion of funds. This certification for us is very important, and I think over the next 3 days we are going to be looking at this in detail, because chartered accountants being chartered accountants want to be clear all the time. They want all the boxes to be ticked. They want all the cross verifications to be done, and if at all there is any divergence or any deviation or any conflict, how to resolve those. Then comes, of course, litigation. I think very few chartered accountants in practice go into the litigation practice with respect to RERA. This is mainly a domain of the legal profession, but I believe we also have a few fellow chartered accountants in GUJRERA who are practicing. I think Advocate Nipun Singhvi is one of them. He practices as an advocate and brings a high level of assurance to whatever he explains. Then, of course, there's advisory. This, to me, is one of the key things where all chartered accountants should aspire to get into, because we are the ones who can join the dots between multiple laws. End of the day, the chartered accountants are also one of the most trusted troika out of the three professionals, because money matters are involved. I think lots of clients, they would be relatively open to taking advice from chartered accountants more than from lawyers. In this business, litigation is A, avoidable, B, very costly, and C, if you want to remain in the business for long, you have to ensure that you deliver the projects. So I would urge most of the chartered accountants to focus on enhancing their skills such as to be very good advisors in the real estate sector. Who are the stakeholders? Let's identify. I mean, the professionals, yes, we discussed it. Chartered accountants are the professionals. There's advocates who issue the draft allotment letter, the title certificate, the draft agreement for sale. There's the architects who issue the various forms, and the engineers again who are involved in issuing various forms. Of course, promoters are the biggest stakeholders. They represent one side of the industry. They are the ones who are driving the business. Yes, we have RERA authorities across various states who are very much keen to raise their standards. One of the things which I observed is that, like Vinay said, RERA is proactive, GUJRERA is the second most proactive. What I also understand, RERA is also proactive. Just yesterday, I think there was a newspaper article which mentioned that RERA has shortlisted something like 200 projects. They have had extensive discussion with the promoters because they thought that these are the projects which can get over in the next 1 year. They went out of their offices, did site visits, they did inspections, and then finally after discussion with the promoters, have given out instructions that these are the projects which can be likely finished in the next 1 year, benefiting almost 30,000 LOTs. So that's something very unique. I have not come across a stage where the regulators go out of their office, they go out and proactively do an analysis of which are the projects which are likely to complete and where the benefit is maximum. In our language, in management language, we call it low-hanging fruit. And then, of course, there's lenders and NBFCs. Again, Vinay made a very strong case that this industry should get industry status because that would then allow them to borrow from the banking sector, and it would be well organized. Till now, most of the industry has been, I think, is dependent on individual financing, high net worth financing, NBFCs and lenders, which are banks, for their funding. I think according to one report, almost 4 lakh crores is stuck up in various inventories across India. Even if 50% of that inventory was released after accomplishment of project completion, that's a lot of money which gets into the system of the economy as a whole. Now, when we did up the analysis, that what exactly is it, that will be the framework of what we are going to do under GUJRERA manual. Now, as I said, RERA manual is also almost complete, or it is complete. I think the manuals, both the manuals will be 80% very similar, but the 20% difference will always be there because of the way the rules, regulations, and the practices in both the regulatory authorities have evolved. So that's just a very gist of what happens. What is of interest is that GUJRERA has almost given 2,805 rulings, which means it is not only proactive in registration, it is also proactive in addressing the complaints. Then we come to what was the objective and approach and methodology which we took or we are going to take. Very simple. We wanted to be very practice oriented. We want to enable capacity building within the profession from advisory services. That is where the key to our knowledge and skills comes in. But for that, we need to enhance certain other related skills with respect to sanctions, with respect to IBC, with respect to GST, with respect to income tax. Only once we have an overall bird's eye view will we be able to provide advisory services to clients. Yes, we all understand we need to keep up with the latest judicial pronouncements. Yes, we want to be updated with the latest circulars. Under the Act, constant improvement keeps on happening. Any loopholes which are figured out or any representations which are made with a view to plugging the loopholes, they may take their own time, but yes, that happens. We need to have best practices in respect of registration, certification, and litigation. And output, our aim was that the output should reflect each chapter written as uniformly as possible. Again, structuring the chapters and parts. How did we structure the chapters and parts? We said that we want to have a general outline of each chapter. There should be an introduction, relevant sections, rules, regulations, and orders of the authority should precede, and then would come the part where it would be elaborated in a progressive manner. This would ensure that any reader the framework, necessary framework right at the start of the chapter, and he is able to progressively add on to his knowledge. Again, procedural aspects of registration, certification, and litigation step by step, where you will be able to look at the screenshots from the website itself, allowing any person to go through the process in a very simple manner. It is not rocket science. We are all used to computers. We are all used to filling up applications on a scale which probably no other profession fills up, be it a bank form or any application or a loan application. So this is just to ensure that you're going step by step into the registration and certification. We wanted to include as many Q&As, citation and judicial pronouncements, flowcharts. We have tried to include that. Now the Q&As, many of them would be outdated because it's almost 4 years gone. We are into the 5th year. Nevertheless, beginners or even let us say a CA firm's articles need to get going from the start. So it is like hand-holding them to get going on the basic level and move on slowly over to the intermediate level of knowledge and expertise. Yes, we wanted to include chapters which intersect with RERA, which is IBC, Consumer Protection Act, Stamp Act, Registration Act, direct and indirect tax laws. They all have an implication on how agreements are structured. How have we done the chapters and parts arrangement in RERA manual? Again, a very broad framework. We had part 1 where I think overview, journey, objectives, authorities. I think primarily Vinay has already discussed it. The other parts we will be discussing, promoters. Over the next 4 days, this is what we are going to be discussing in detail. Definitions of a promoter, functions of a promoter, how the registration happens, what is a RERA designated bank account, how do the project updates happen, QPRs, revisions, extensions. These are all process driven and procedural driven. How it has been prescribed by the various authorities. Then there's of course section 15, assignment of projects, transfer of title, importance of possession date. They all come under the obligations of the promoter. And then what really happened? What was the impact of RERA on advertisement? I mean, everybody is clear that you cannot advertise until you have the project registered. You cannot sell until you have the commencement certificate for that particular unit. So how it has changed the business processes, and of course, what is the biggest impact of COVID? I mean, I believe that everybody has been struggling, or there has been a huge disruption in all kinds of economic activity, and this sector is no exception. Part 3, we are just talking a very simple one. There is a provision with respect to agents registration process and documentation, basically section 9 and 10. And then part 4, LOTs. How do they come into the picture? You know, prior to RERA, LOTs was apparently nowhere in the picture except when they did go into a civil suit. And they were always at the receiving end. One of the driving factors of bringing in RERA was to ensure that the LOTs have some relief. So yes, what LOTs, what are their rights? And there, yes, there's a small portion of their duties. But what happens in case a project registration is revoked? What happens if projects are stalled? And how do we revive them? Again, there has to be a way out, and there's no clear way out right now, especially when this intersects with insolvency and bankruptcy code. Who gets the priority? So I think the Amrapali case has brought in some kind of balancing with respect to the rights of the LOTs versus the IBC code. Again, this is an evolving subject, but let's hope for the sake of the LOT that things move favorably over a period of time such that they can receive possession of the flats where they have invested. Yes, in case projects are stalled, how does the association of LOTs come into the picture? If the conveyance does not happen as has been defined under the law as well as under the rules, how do you go in for a conveyance? And yes, due diligence before buying property. See, the values of properties have gone up over the last 10 years in a very big way. Anybody wanting to make an investment would like to ensure that he has done some due diligence. I mean, 10 years ago, everything was word of mouth. But since things started falling through the cracks and more builders started running after land banks and started leaving wide open projects which never saw the light of the day with respect to project completion, it is now becoming essential to do due diligence before buying property. Now, I do understand that anybody doing a due diligence does not want to pay for the kind of services which we can offer. But I'm sure that over a period of time, it will become a norm where people will, potential clients will approach chartered accountants, asking them to do a level 1 or a level 2 screening for them such that they can invest. This is just the second part. What is the professionals in the scope? Again, title report, draft letters of allotment, draft agreement for sale by lawyers, architect certificate, engineer certificate, CA certificates, and audit of real estate entities. Now, how does that interact with the normal audit which we do, and the kind of obligations which have been cast both by the rules and the regulations of GUJRERA? We will be analyzing that. Complaints is another big scope, part procedural driven, part knowledge driven. So there's various kinds of complaints, how the process of inquiry happens at the regulators level, how do appeal, second appeal, and execution of orders go through. Again, I think Vinay had a slide which explained what is the hierarchy of complaints and the appeals. Then we have complaints by the Association of Allottees, offenses and penalties which have been prescribed. I think we have not, and most of the regulatory authorities have not gone very hard with respect to offenses and penalties in a big way. However, any act or any regulator has a stick in his hand when he uses the offenses and penalties to ensure that it is a deterrent and proper behavior is observed by all the stakeholders. Maharashtra, there is a process of conciliation. It's again a very unique process. I'm not sure whether it is there in GUJRERA. Yes, then there is discussion on taxation laws, income tax, GST, both direct, indirect taxes. Again, this understanding of this will help with the structuring of the agreements. Part 8 is allied laws and sanctions by competent authorities, FEMA, PMLA, CPA, IBC, etc. And part 9 is the constitutional validity, and to Mumbai in specific is the redevelopment. So constitutional validity, we go back again to the Neel Kamal suburban realtors case. As Prabhu sir mentioned earlier, it is one of the most important cases. People should consider it as a Bible. Whenever there is any doubt, there's a wealth of knowledge and interpretation. It's insofar as we are concerned for RERA, it is all the jurisprudence which we would like to really understand and borrow from to ensure that we are able to give a good service to our clients. Now, challenges for the stakeholders, lessons learned on account of financial stress and factoring changes in law. See what happened, RERA came in from 1st May 2017, July 2017, GST came in, somewhere in November 2016, we had the demonetization, then we had the IBC come in. Now, all these have ensured that the stress, financial stress on account of all these changes in law has probably aggravated the situation, as the industry leaders are pointing out to. And the cause and effect of rules and regulations, there's some regulators who are lenient, there are some regulators who are stringent. See, leniency in registration would probably lead to more complaints. Stringency in registration would have lesser complaints, but then it is at the cost of development of the sector. So where is the balance? Eventually, we as professionals must understand that there will be some kind of balance. So our wish list cannot always be satisfied by the regulator. We may always keep on thinking that if only the regulators brought this in, the allottees would more. I mean, as of now, it is mainly the allottees, but over a period of time, I think even the allottees who have got the relief which they have sought. As I said earlier, do not be judgmental. There has to be a balance between regulation and development. Best practices at regulatory authority levels are still evolving. So, look, it's nice that we are able to collate what kind of evolution is happening with UP RERA, with Maha RERA, with Guj RERA, with Tamil Nadu RERA, with Karnataka RERA, and I think over a period of time there will be a convergence of the best practices at the various authority levels. It will be probably a 5 to 7 year period. after the enactment and the law has gone into effect. But yes, we will likely see a good convergence. Now, this manual will be only a tool, and domain knowledge should be absorbed very well. I urge all CAs to understand the domain knowledge with respect to real estate companies, with respect to sanctions under the various laws by the competent authorities. Only then can they have a better picture. Something which I like to say every time, that look, creative paper solutions towards compliances are not a good substitute for project completion. We may not be able to tell the client all the time that, look, just because your non-compliance has brought you to this state, do not expect a miracle that the documentation, if you do a documentation, the project will be complete. So please focus on project completion. There is nothing better than having a project completed. And in case of doubt, go back to the objects and reasons of the Act and refer the Nilkamal Suburban Realities ordered by Mumbai High Court. You will always get an answer to whatever you have been looking for. So what I would say, the dynamic nature of real estate sector and the construction sector contributes to the economy along with rapid urbanization. One of the reports I came across projected Gujarat to be the second most urbanized state after Tamil Nadu by the year 2030. That is approximately 67%. Maharashtra, incidentally, in that report was placed at third position, and Tamil Nadu was placed at first position. Now, if rapid urbanization has to happen and whole of Gujarat has to be considered, I believe that as of unlike Maharashtra, where whole of Maharashtra comes under the competent authority, whole of Gujarat has not been notified to come under all competent authorities. So over a period of time, we will see more and more geographical areas coming under the jurisdiction of competent authorities. So great investments will come only if there is a reasonable regulation in place. And without a plan, see, most of the time what we find that builders do not have a plan. What I find with respect to GUJRERA is that they demand Gantt chart and project schedule. This is really, really wonderful. This is a step ahead. It is wearing the engineer's hat right at the start, not just the financial hat. And we all know that without a plan, no one succeeds. So, Act being pan-India, I see that we will be moving to a stage where this sector grows in a very big way. All those who want to come into practice in this must start at the earliest, and believe me, in 10 years' time, this will be a huge practice area for chartered accountants. This is all I have to say with respect to this presentation. Thank you very much. Aditya ji, we can't hear you.
Sorry. Thank you, CA Kaushik Sampat, for your deliberation. You have very gone through the practice areas, the various stakeholders and chapters and part, and explain in detail the chapter, parts, arrangement, structure of the RERA manual, and also challenges for the stakeholders and what professional opportunity we have in the RERA to practice, and the way forward, what it would come in the near future. So I, on behalf of WSU of ICI, propose a very hearty vote of thanks. And thank you. And we will look forward to listen from you in near future also on other topics.
Thank you.
So now coming to the next topic for the day. Next topic is revival of stall projects under RERA and promoters and their obligations under RERA. And that would be taken by CA Sunil Nayak.
Aditya ji, Sunil Nayak sir was held up in the court since morning. So he has requested me to go through his presentation. And I think he has two presentations today. I will just change the order of the presentation. The first presentation, instead of revival, we are going to be doing the functions and duties of promoter. I request that the slide presentation which I have put up, I be allowed to do the slide presentation here, show my screen. So you can still introduce the speaker because he will be joining in from tomorrow. I'm just a stand-in for Sri Sunil Nayak today.
Okay, yeah. So, in absentia of Sri Sunil Nayak,
Yeah, I think we can introduce him tomorrow. Hello, Aditya. Anyhow, he is coming tomorrow. So let us introduce him tomorrow only. Kaushik bhai, you can go through the presentation. That will
I will.
Whatever suits you, sir.
Yeah. With your kind permission, can I go ahead, sir?
I think you should. Yeah. Thank you.
Okay, my slides are visible. First slide.
Yes.
Yeah, visible very much.
Okay. See, what we are going to do, in one of the parts we discussed, promoter is an important stakeholder and what kind of functions and duties come under them. We just elaborate on that, the objects of the Act, I think anybody who has read the Act probably has gone through this particular slide in a very large detail. The objects of the Act were there basically to address these shortcomings and deficiencies and the lacuna where there was no law in place earlier. The allottees or the buyers basically had to run from pillar to post. Securing civil remedies was a long drawn process. How the Act came in and what kind of characteristics it had and what kind of issues it is addressing. So yes, everybody knows it is to ensure accountability to allottees and protect. This is the first objective. Again, in my previous presentation, I said whenever there is a doubt, go to the objects of the Act. Once you go through the objects of the Act, it will be very clear to you what kind of decision you have to make. Second is to infuse transparency. We'll go through that, how it infuses transparency, how the online applications are ensuring that people have access to information which is on a public platform and not previously available. Again, with respect to GUJRERA, I understand the level of detail which goes through is phenomenally high. When you go through a particular project, you can even see the name of the allottee, which comes as this is something very advanced insofar as I can think of it. Yes, there has been a professionalism and the march towards pan-India standardization is very, very good. Again, I had made a forecast that look, in 7 years' time, we will probably see a convergence of the best practices by most of the regulators. Yes, there will always be adaptation to local conditions and constraints. I'm not saying that everything will go positive. Constraints are always there. But yes, we will see a good deal of convergence. And we hope, for the sake of the sector itself, that the sector grows on account of standardization. Everybody understands the rules of the game much better. Then yes, imposing responsibilities on both promoter and allottees. Promoter previously used to escape with his compliances because the regulator had no teeth. RERA has been given adequate teeth for the regulator to go out and impose conditions, issue such directions as may be necessary. Now, what we have seen is, as of now, it's been a little bit slow with respect to all kinds of regulations and compliances. The main reason being that there had to be a transition which was supposed to be made for projects which are already under construction and execution. So we had two types of cases for ongoing projects and new projects. I believe that the ongoing projects which were registered in 2017, they are yet to run into the full course and reach the completion date. Many projects have been completed, many projects are still incomplete. And once that runs out, when the new projects registration is happening, I think there will be a stricter regulation as well. So we are seeing two kinds of regimes, one for ongoing project and one for new projects. GUJRERA, of course, has been very proactive again. They have ensured the QPRs. I'm very impressed with the QPRs. A very similar thing has been adapted and adopted by RERA, though not exactly line by line. So look, this is where the positive impact seems to be rubbing off. Now, to establish regulatory oversight mechanism to enforce contracts, here when it means contracts, basically between the allottee and the promoter. And fast track dispute resolution mechanism, Yes, we may use the word fast track. It is anything but fast track because there's been a huge pendency of cases. Nevertheless, there is a dedicated forum available to take the dispute and there is a dispute redressal system in place. And to promote good governance in the sector, which in turn would create investor confidence. This is the larger objective of the Act. Now, LOT, we just go through a couple of definitions which tell us who exactly an LOT is, and it's been very well defined. It includes any person who to whom a plot, apartment, or building, as the case may be, has been allotted, sold. All kinds of words, legal words and jargon have come in. Of course, there would be legal luminaries who would find some loopholes in the working in the definitions, but by and large, I think one of the cases which is being discussed is whether industrial plots would fit into this or not. There's been kind of different approaches at the different levels of High Court as well as at the expert lawyers level. But we hope that over a period of time that conflict will also be resolved. And what has been also specified, who is not an LOT, is a person to whom such plot is given on rent. So it has been clearly established that if you want to give something for rent, you are out of the picture. The reason being, the promoter right at the start of the project, if he is clear that I am building this commercial building and I am going to rent it out, then there is no need for any LOT to buy that property, or there is no need for him to sell it out, unless, of course, he is selling out to an LOT and there is an investor LOT, in which case the registration would have to happen. Another area which is very contentious is the carpet area. Now, what this RERA has done is they have defined the carpet area, and in all fairness, all the competent authorities across India, I believe, are transitioning and bringing in the same definition of the carpet area as has been defined under RERA. So either they will change their definition through whatever directions, or they will say that carpet area shall have the same meaning as under RERA 2016. RERA also came out with certain sketches, diagrams to illustrate what is included and what is not included. So this actually takes away a lot of loosely used terms in the past and ensure that carpet area is now uniformly defined across in the country. It will take some time in the various states for people to get used to it, but I'm sure over a period of time, this standardization is going to be of great use. As I explained earlier, that in Mumbai, we have heard very fancy terms of saleable area, and we have the built-up area, which is actually the area which is regulated by the competent authority. And then there was something called loading. So it was a function of how the builder wanted to market or advertise his product. Now, carpet area basis is there. There is no artificial notional loading permitted. So the LOT now is in a position to compare rates and take informed decision. Again, promoter. This is the key aspect. Who is a promoter? Here, to the extent possible, I think the framers and the draftsmen have taken into cognizance so many definitions of promoter. Yet, something could be missed out, and I think over a period of time, the courts or the appellate authorities or the courts would probably give a finality to the definitions of the promoter. The reason being that no promoter now wants to bring in all the land. There are more and more joint ventures, there are more and more joint development agreements, all kinds of structures are being used so that the developer is not buying out the land, he is focusing more on the construction part, and then of course the commercial terms and conditions, all kinds have to be accommodated in the agreement. So you have a promoter who constructs and causes to be constructed an independent building or buildings consisting of apartments, existing building, inclusive assignees, all inclusive definition to ensure that nothing falls to the cracks. Yet, as I said, something may fall through the cracks, but the courts or the judicial and quasi-judicial authorities will likely address it at the earliest. Next 2-3 years will sort out all kinds of conditions and the agreements which would cover this kind of definition. Then, yes, as we know, in Maharashtra, previously plots owned by government authorities or body or placed at the disposal by the government was excluded. Now it has sought to be included. See, government is the largest land bank holder, and by way of social policies, they provide for economically weaker sections. They also provide for low income group, make available lands such that it becomes affordable to them. Previously, they were not included, so right now they are also included. And I think it's a pan-India situation, not just in Maharashtra itself. Then you have Apex state level cooperative housing finance society and primary cooperative housing society which constructs apartment. Here it's only a structure which is sought to be brought within the ambit of the promoter. Again, the idea is to ensure nobody is missed out. So it is an inclusive definition. Then there was a word, you know, some places, any person who acts himself as a builder, colonizer, I don't know which state has basically has the usage of the word colonizer, but then there's contractors, there's developers, or estate developer, or by any other name, or claims to be acting as the holder of power of attorney from the owner of the land, whether it is constructed or plot is developed. So again, it brings into its ambit a wide net to ensure that nobody gets away by just playing on the words. The idea being that the allottee, who is the primary beneficiary of buying any apartment or plot, benefits out of this regulation and is not left out just because of play of words. And yes, there is also a deeming provision with respect to promoters, because what happens in certain agreements, you have the landowner and you have the developer, and their scope of work has been explicitly written down in their agreement. Now, just because a landowner provides the land, his scope remains only with respect to the land. If there is any default by the developer who is doing the construction, the landowner should not be held responsible. So it is something like the rights and obligations arise out of the kind of agreement which they are signing. So there is a bit of a clarification, and I think there is a little bit of conflict also going on. Hopefully over a period of time, it will be cleared. Now, what is a real estate project? Again, a very simple project, that it means development of a building or a building consisting of apartments, converting an existing building or a part thereof into apartments, or the development of land into plots. So again, all kinds of development and all kinds of selling of those lands, including common areas, development works, improvements. So again, it brings into its ambit. Suppose there is a separate bungalow and somebody just builds around the bungalow or above the bungalow. He should not claim that, look, I was excluded because my building structure was already standing. So long as there is a development and so long there is a sale, it will attract the provisions of RERA. Now, how does RERA bring in the legal discipline? Now, declaration giving all the project information, and that the affidavit to the effect that developer has legal title or development rights, including encumbrances. See, even the competent authorities require affidavit to that effect, just to ensure that nobody does a forgery or by any other fraudulent means he takes over any property which does not belong, or the title or is not yet clear how he has acquired the rights. This is the reason why there is an affidavit. Because if you sign something on an affidavit which is not true, you are also liable for criminal prosecution. Agreement to sale format is strictly adhered to as provided under the applicable rules framed under the RERA Act. Model agreements have been prescribed. However, it comes with a disclaimer, and because of that, I think all the existing or ongoing projects still have a baggage of previous agreements which were one-sided. Maharashtra has taken a first step in bringing in having a committee go through this. I think the committee has been formed last month. Its report will come. Whatever I think the first regulator will try and bring in as mandatory clauses versus optional clauses. I think will prevail, and that lead will be probably taken over by all the regulators in the country. So yes, model agreement for sale, still a gray area, lots of litigation going on account of that, unnecessarily clogging up the system. Then previously, I think all kinds of loopholes were being exploited, not to register an agreement either by the promoter or sometimes in collusion by the allottee as well. Now RERA says you are a serious buyer, we are there for you, but yes, you have an obligation unless and until you register the agreement. After collecting more, you cannot collect more than 10% unless an agreement, unless and until you go through the registration process of the agreement. Then promoter cannot sell or accept booking money unless the project is registered. This is the biggest game changer. First, we have to register. However, initially I noted that people were using the words in their advertisement as RERA approved. It is never RERA approved, it is only RERA registered. The kind of scrutiny which goes through will differ from regulator to regulator and state to state. However, it gives an assurance to the buyer that a formal registration process has been gone through. The kind of documents which are prescribed have been furnished by the promoter, and in all probability scrutinized lightly, leniently, or stringently by the regulatory authority. So this is the first level of assurance. Again, 4.2 LD is to ensure that there was no siphoning of funds or diversion of funds. I recollect that there was a big debate when the act was about to be passed or to be enacted on whether this amount should be 50%, it should be 70%, it should be 90%. See, what happens is a big chunk of the total project cost in what I call South Mumbai will be land cost, and the construction cost will be relatively small. If we go only to North Mumbai, that ratio actually changes. And if we go over to a pan-India basis, the ratio changes from city to city, metropolitan city it will change, tier 2 city, tier 1 city, everywhere it changes. However, when the 70% came out, which I think was supposed to be a good compromise, I think a good benchmark has been set that there will be no diversion of funds. So that's the history to this 70% as well. And then yes, due certification of utilization of money has to be obtained by 3 professionals. One of the cases where I think people who get lost is trying to compare the percentage of completion. I urge chartered accountants, read all the certificates carefully, compare the wordings of the certificates which are prescribed, and try not to jump to a conclusion that you are supposed to, as a chartered accountant, you are supposed to compare the percentage of completion which should tie up. Believe me, it will not happen, because an architect has different basis to compute his percentage of completion and his milestones. An engineer has a different basis. He is focusing only on the structure which is to be constructed, and a chartered accountant is going through all the costs of the project. So by and large, you cannot compare apples with pineapples. So please do not get lost in this percentage of completion. At best, understand that there should be no major deviation in the elements of cost which have been considered by the engineer and the elements of cost which have been considered by the chartered accountant. Then yes, yearly statement is to be, a statement of account is to be submitted, audited by a chartered accountant within 6 months. This is part of the system which ensures that the funds are used only for the project. Yes, this is what we discussed, how it does the counter check and how there is a 2 level of checking with respect to it. A chartered accountant who issues a certificate for withdrawal is also has an oversight with respect to another chartered accountant who reviews whether it is in line with 4.2 LD or not. This mechanism, dual mechanism, places chartered accountants in a very key position, and I believe that they will take this seriously. I also understand that in Gujarat, one of the chartered accountants has had a case, disciplinary case filed by him against GUJRERA. It should serve as a lesson for all that please take your certifications seriously. Do not just sign on the dotted line. Performance discipline. How does it bring a performance discipline? One of the things is the estimated time period for completion of the project has to be defined right at the time of registration. Yes, this particular aspect was dealt with in great detail by the Bombay High Court in the Nilkamal Realtors, Suburban Realtors case, and they have commented and given their observations and remarks that look, there will be cases that where extension will happen. Yes, the law says that there will be an extension only up to one year. What next after that? So the case has said how the various regulatory authorities will go ahead and consider case by case basis extension as well. So look, what seemed initially to be a dead end in respect of projects which could not be completed in the time or extended time, the Mumbai High Court order has clarified that a case by case basis extension will also be considered. Then yes, further extensions, that's what it is. And then there was a penal action. See, what happens is, we all say there is penal action. Penal action, if the project goes off rails, let us be very clear. Getting the project back on rails is a very, very tough proposition. Whatever the reasons with respect to the project going off rails. So it's better that all the allottees also who have access to the information on the website constantly follow up, do a cross verification on what kind of data has been uploaded on the web portal of the relevant state, to keep track of the progress, compare what has been progress, follow it up with site visits. Anytime you invest money, you want to ensure that you safeguard it. And since the amounts are very huge, you have to safeguard it. Delayed project implementation. One of the major challenges came in with COVID-19. And then you had the ministry at the central government level as well as at the state government level who came out with various kinds of relief which affect both the promoters and the allottee. End of the day, the idea is that we need to get the projects completed. So kind of leeway was given. There was probably a compromise here and there, but yes, COVID has dealt with this. But yes, they also ensured that consent of 51% of allottees is considered, and there is a strict measurement criteria with respect to implementation schedule, operational accountability, etc. This onus is more on the authorities, and as and when authorities start exercising these powers, it will greatly benefit the allottees. Now, Section 11 to Section 18, basically speaking, the main contents of the Act are from Section 2 to Section 19. Then are all the other powers, authorities, administrative powers, procedural powers, power to disqualify, annual accounts, blah, blah, blah. But these are Section 11 to 18, which are the functions and duties of the promoter. Now they are spread over so many sections. They are not brought, the law has not defined it all under one section. It has been elaborated topic-wise. So we just go through. First is advertisement. Yes, when advertising, promoter is required to prominently disclose the details, website authority of the website address of the authority, and GUJRERA registration number of the promoter. I think this is probably common to all the regulators in the country. And then again, what happens regarding the veracity of the advertisement of prospectus? If there is untruthful or a misrepresentation by the promoter, what kind of relief can the allottee claim? So yes, there's a cause and effect to it. He is liable to return the entire investment with interest. Yes, something like this doesn't happen automatically. The allottee will have to file a complaint and follow through with his rationale for it and with the necessary supporting. Again, that's what we have discussed. I think when the Act was passed, on TV there was kind of a jubilation, and I recollect the Vice President, who was the then Minister Venkaiah Naidu. He had used a very simple phrase: the builder has to do what he has promised to do. This is what the Act is aiming for. So this is the in a very nutshell. Please deliver the projects, complete the projects. That's what is happening. Here we should be very clear. In Maharashtra, and I believe in all states, phases has been allowed. Phases can be either horizontal, which means on this plot of land or this small portion of the land we will build later on. On this plot of land in Maharashtra, there is also on vertical phasing, which means we can register a project from 1st to 10th floor. We can register a separate project from 11th to 20th floor. So there's both kinds of phasing, vertical as well as horizontal. But the promoter has to be very clear as to what he is promising at what point in time, and he should capture it. I mean, normally the amenity is completed the last, but if the promoter is giving possession or by part occupation or due to phasing by different dates, he is very well advised to ensure that he makes a clear-cut disclosure of what kind of amenities will be delivered by what date. So this is just a precaution to be taken, and that's what the brochures and the advertisement should contain. Very simple, we have discussed this earlier. Agreement has to be signed. We cannot collect more than 10%. Very mandatory provision of the Act. This is to ensure that the interest of both the promoter and the allotee is safeguarded. Now, what is this is done basically is to ensure that kind of investors who are in the project will have to get in through a different structure, and it is mainly in the interest of the end user allotee. So be aware that if an investor is going to come in, you have to be very clear if you are advising your client how he is to go through the structuring of the agreements and the structuring of the transactions. Adherence to sanction plans and project specification by promoter. This was one of the biggest deviations which was happening, and which kept the allottees up in limbo. Till the end, they did not know what they have signed up for is what they will get. And the promoters, by various excuses or whether it was through competent authority directives, they could make constant change in plans. This has been taken away now. Minor, yes, exceptions have been carved out in this particular definition, that minor additions and alterations as required due to architectural and structural reasons are permitted, provided a proper declaration and intimation is done to the allotee. Again, the communication loop has to be closed. So we go over, yes, what used to happen earlier was that RERA has ensured that if a whole family was investing and there was some kind of loophole in which a family members bought 5 flats, for this purpose they are saying that they will be treated as one. That is to ensure that the brute majority does not basically overrun on a minority through this route. Defects liability, very simple. Defects liability is there for 5 years, basically for structural defects liability and poor workmanship. Defects liability does not mean that any kind of normal wear and tear or any kind of negligence has to be made up by the promoter for the next 5 years. Once a promoter hands over, he does the conveyance, he does a handover, he's probably out of the ambit of this particular section. However, only in case of structural damage and bad workmanship, he will still be liable to be called in. Assignment of real estate projects. Section 15 ensures that the promoter has the obligation of ensuring that any time he assigns or he passes on the project to any other promoter, what is the mechanism through which the baton passes and what kinds of rights and obligations the next promoter, incoming promoter, will have to comply with. Again, it's a 2 or 3 step process. Allottee's consent is required. Regulator's consent is also required. So look, this 2-step process ensures that nothing happens behind the allottee's back, and if at all he has to be a part of the process, he has been properly explained and communicated, and any clarifications which he seeks is to his satisfaction. Obligation to transfer yeah, this was just part 2, obligation regarding insurance of real estate project. Look, this insurance was basically brought in for title insurance. I don't think so that the market in India is so mature. At the same time, I think CA Vinay also explained that we still have issues regarding the title. There is a Model Titling Act which has been brought in by the central government. The states are supposed to now enact it. Maybe it will take another 2 years, 3 years, the law will be passed, the mechanisms will be prescribed, and the author persons who will be authorized to ensure that a titling certificate is given. So look, it's a work in progress. Pending that, we still don't have insurance which is given for title insurance, and this section has not been rolled out in full. However, there are other insurances which are still applicable, like construction all risk insurance, which I believe that every promoter should take. There is nothing to bar him from taking that kind of insurance. Yes, we then move on to the transfer of title. One of the biggest lacuna, or one of the other lacuna which was prior to enactment of RERA, was that promoters were not executing registered conveyance in favor of the allotee as well as to the association of allottees. This has now been mandatorily brought in by section 15. Again, the rules and the regulations would specify what kind of percentages of buyers have to be brought in and what is the time frame to be brought in. They are again defined both by the law as well as by the local laws pertaining to conveyance and registration. Then what are the other functions and duties of promoter? See, section 11 gives out lots of responsibilities. One is to obtain completion certificate and occupation certificate. This is a very simple thing. Not all competent authorities issue both. In case competent authorities issue just one completion certificate as per their practice in their state, that will suffice. If both are supposed to be there by the law, by building bylaws, then both would be required at some point in time. This is just an extension of the concept that yes, completion certificate should be issued and they will be handed over to the association of allottees who is taking over. There are also times when building projects are built on leasehold land, and this defines the method in which the leasehold land obligations and responsibilities are passed on to the successors, which is the association of allottees. They are responsible for maintaining, till the proper handover happens, they are responsible for maintaining the essential services on reasonable charges till the taking over of the maintenance by the project. See, typically what happens is all the units are not sold upon completion. It may take 9 months, it may take 1 year, it may take 2 years. So till such time, all the apartments or the units are sold, the promoter would like to keep control so that he can ensure that he is not stopped from getting inside the project site and he is allowed to complete his part of the sale. It's a balance on both sides. So that's what this provides for. He has to pay the outgoings till he transfers the physical possession. Again, very simple. He has to form the association of allottees, whatever way. There's plenty of structures. There can be a private limited company. There can be a cooperative societies act. There can be under Maharashtra, there is a Maharashtra Ownership Apartments Act. So whatever shape and form the structure takes, he has to ensure that he passes it on. Then there are also situations where there are very large land parcels which are developed in phases, and each one of them, for example, let's say there's a large parcel of about, let's say 50 acres or 100 acres. Now these are long-term projects. They take anywhere between 15 to 20 years to complete. So the first project will be completed, let's say after start by the 5th year or 7th year, and the last project by 20th year. So as soon as the first project is completed, the builder would hand over the conveyance with respect to that building to that association, and over a period of time we may find that there will be 5 or 6 or 7 different association of allottees, and because they all have a very common area or amenity which they are all sharing, the structure goes over to an apex federation, apex body or a federation. So it just basically caters to that kind of structuring over here. It's explicitly stated, so nobody is left wondering, and nobody now needs to go over for clarification to any courts with respect to that. Corrective action, again, it's the same delay in forming a society, how it takes place. Return of amount, now section 18 is basically with respect to the failure on the part of promoter to complete or unable to give possession. This is a very detailed section, because most of the litigation, or I would say 80 to 90% of the litigation, is under this section, again because of the baggage of incomplete projects at the time, or projects which were still under construction, or ongoing projects as we define it. We won't go into this in detail. There's plenty of literature out with respect to the facts and circumstances, as well as the method in which the legal cases have been dealt with by the appellate authority or a quasi judicial authority. So no act can be complete unless the obligation of both parties is defined. So there is rights and duties of allottees as well. Yes, it's very simple, not more than 5 or 6 provisions with respect to that. Yes, there are also situations where allottees, basically investor type allottees, who did not want to take possession due to whatever reason, would not come over to take possession, and they would do a cross litigation. So here it is well defined what kind of rights and duties are there for the allottees. Then there is a dispute redressal system. Who can file a complaint? Any aggrieved party can file a complaint with GUJRERA. So look, people must go through, chartered accountants must go through who can be an aggrieved party. Previously, we used to have situations where any Tom, Dick and Harry could come and file a complaint. Now that is restricted only to an aggrieved party, and it's defined in the Act itself. And yes, the mechanism, it's a 3-step mechanism. First complaint goes to the authority, then it can, if it any party which is not happy, it can go to the appellate authority. Time frame is defined. If the appellate authority is also resulting into something which is not satisfactory to the either the complainant or the respondent, they can go to the High Court and then the Supreme Court. Of course, High Court and Supreme Court is only a question of law. You cannot go on the facts of the case. So the corrective mechanism is also there. This basically is where RERA has got teeth, along with the offences and penalties. So the offences and penalties, here's the table, section 59 onwards, there's a big table of offences and penalties. I think both GUJRERA and MAHARERA have made very good use of penalties to act as deterrents. The quantum is basically initially proportionate to the kind of compliance which has not been met with. There have also been quantums where very large penalties have been levied in Maharashtra on account of non-registration of the projects. So here's a table along with the complaint redressal system and the offences and penalties. Here is where RERA has the teeth. I think this is what we have discussed. I would like to end this particular presentation. In case there are any questions, I would suggest that the participants just send them over. Probably CA Sunil Nayak will address them separately when he takes further sessions. Thank you very much. Sir, who's taking the process forward?
मिश्रा जी,
मैडम।
हाँ मिश्रा जी कौन है अभी? आदित्य जी होंगे ना? आदित्य जी होंगे ना?
हेलो
आदित्य जी।
आदित्य जी नहीं है अभी यहाँ पे? Okay, okay.
So thank you, CA Sampat ji, for a very lucid presentation on the topic, which was originally allotted to Sunil Nayak sir, but you have taken up in a very detailed manner, and we cannot say that we have filled in the shoes, but he has taken a very good manner. So I request CA Pinky Kedia to kindly present a formal vote of thanks to our speaker, Kaushik Sampat.
Thank you. Thank you to giving me this opportunity to give vote of thanks for Kaushik sir. Actually, we are working since last 1 month on a project, and I know Kaushik ji very well and very good in RERA, and he's very kind person also, very knowledgeable person also. I learned many things from him, and he has presented all the things in such a lucid manner, and in such a short time he presented very good thing, large important things to us. So on behalf of WIRC, I request everyone to give a vote of thanks to him, and thank you Kaushik ji to enlighten us for this topic. Thanks a lot. Thank you.
Thank you, Pinky ji, but nobody is going to escape the following presentation, so it will be a hat trick of presentations. Again, I'm standing in for Sunil sir, and he is far more knowledgeable and far more experienced than I am. I only hope that I've been able to cover and elaborate on his slides to the satisfaction of our participants. I noticed that there are almost 50 plus participants, and I hope that people do absorb whatever is offered on this refresher course. Please ensure that you take down your notes as well. These are things which may not be available in a very easy format, easy way. Reading through is very difficult, and grasping through all that is very difficult. So I urge people even to raise queries, because that will stimulate their mind to understand the subject better.
मिश्रा जी, वहाँ कोई क्वेरी आई है क्या चैट बॉक्स में? कोई क्वेश्चन नहीं आया. So if anyone have any question, you can put in your chat box, and we can. Kaushik ji, are you there since till 8 p.m? So we.
Yes, I am there till 8 p.m. I am there till 8 p.m. But let's hope we complete fast. I have been speaking non-stop.
Okay, so I request all participants, if they have any query and they want to ask anything with, from Mr. Kaushik sir, so they can put their queries in chat box only. After the session of Sunil ji,
Pinky ji, I am proposing that Sunil sir will answer the queries tomorrow when it other sessions. I will not be getting into the query side today. Let's complete this portion of stalled projects as well. It's a very important topic.
Okay, fine. Then we will go forward. Thank you, Kaushik ji.
Yeah. Good evening once more. Again, I am standing in for CA Sunil Nayak, sir. We went through a lot of framework of the law. We went through the framework of the manual as well. We went through what is actually a promoter, what are his functions and duties. However, despite all this, because of the backlog and the way the ongoing projects were registered, we are also seeing that the previous baggage is not has been carried forward, and there are projects which are stalled. So we will just discuss on a broader level how to revive these stalled projects. Is my slide clear, visible to all, sir? Any confirmation from anyone? Hello?
PPT is not visible, sir.
It is visible or not visible?
No, sir.
Oh, 1 minute. Okay, somebody needs to give me the power to share. Yeah, show my screen. Correct.
Yes, sir.
Yes. What happened again? Okay.
We can go.
Yeah. I think it's okay. We are on now. What is exactly a stall project? See, stall project has not been defined under the Act. So we have to fall back on the dictionary definition that it is to halt the motion or progress or bring to a standstill. Now we have all seen that ongoing projects were registered, many of which were already in trouble and financial stress, or stress due to any other reasons, either sanctioning authorities or some other change in the law or some other factor which was not factored in by the promoter when he launched the project. So in parlance of real estate project, a stall project is where one which has come to a standstill and not making any progress or is inordinately delayed beyond its normal date of completion. That's exactly how the stall project is. I repeat again, it is not defined under the Act, so we have to revert back to the dictionary definition. Now, what could be the possible reasons for stall projects or projects to becoming stall? It is not that always it is the financial factor. There could also be a change in the regional framework of competent authority. And there have been plenty of examples, I think a couple of examples in Maharashtra, where the jurisdiction of various authorities had to be redefined. And when the jurisdictions were redefined, there was rezoning, etc., or some kind of reservation by the local body. And all of a sudden, a project which has to be started or where even approval was given by the previous authority, the promoter had to redo the entire application, and he found that he could not go through because of some other constraint which was brought in. So that's the kind of framework in which a project could be stalled. Yes, stress projects, I think, is the maximum attributable projects which are stalled are because of financial stress. Other reason is that there is a defect in title of lands as notified by revenue authority. Now, what exactly is that? When a revenue authority notifies it as, let us say, no development zone, or they say this is now coming under the forest area and which is under this Wildlife Act or under this Environment Protection Act, this particular zone, it falls into this buffer zone. Your project just cannot go ahead, irrespective of what you say. So yes, as notified by revenue area, this is one of the way projects can be stalled. And then project becoming non-feasible due to lack of sale and recovery. This is the financial stress and the marketing stress which I was talking about. In addition, there are many other reasons. And I would say 70% of the past baggage of stalled projects is on this count. This diversion of funds, siphoning off of money, excessive spending by the promoter, illegal or improper trade practices, or which now under this act has been defined unfair trade practices. There's change in the market conditions as well. Borrowings at heavy interest rates. See, for a long time, from probably I'd say mid 80s till probably the time the law was brought in, almost 20-30 years, promoters had a free run because there was no regulation. Or regulation was light, or the previous laws did not have the teeth. Sort of they had a free run. So the practices which otherwise were unusual, after a period of time, they come to be accepted as a standard market practice. People just say that if I also don't do what the other guy is doing, I will not be in the market, I will have to get out of it. So all those kinds of practices came over. Plus there was a general inflation and a rise in the demand because of rapid urbanization, which ensured that the prices just kept on rising over a period of time. So borrowings at heavy interest rate in the end turned out to be a very good reason why projects became unviable. If a flat or an apartment or a unit is unaffordable and a market is not going to respond positively at that price, your project just won't go ahead. And funding, nobody has an unlimited funding or is going to get an unlimited funding to complete the projects and then wait for the next 5 years for it to sell. End of the day, there is a cost of money and cost of finance. So yes, borrowing at heavy interest rate was one of the reasons. Then there was a lack of supervision and monitoring of project expenses. Again, many promoters were either lacking in the skills and the knowledge which come with in this business sector, or they were neither engineers or architects, or they were simply traders who just jumped into the bandwagon thinking that this is a great sunrise industry, we can also do it, having no background or skills. Understand one thing, nobody can just become a promoter like that. You have to have the knowledge and the skills plus the entrepreneurial drive to become a promoter. So when I see that people try and say that, oh, we will basically outsource this to this engineer and outsource that to that architect, I simply ask a simple question: who is going to be the driver of the car, or who is going to conduct the orchestra? If you don't have such a person, forget it that you as a society can redevelop any project just like that. You need to have the skills and the knowledge which come only over a period of time. Then yes, in Maharashtra in particular, we also have promoters have been basically jailed for illegal activities and unfair trade practices. Many of them are still in jail. The reason being they have not completed the projects or siphoned off so much money that they would probably believe that yes, it is in their interest not to come out and complete the projects. And then there's also multiple litigations for minor things or minor oversight like title, sanctions, not paying back the loans, not meeting the covenants, not meeting the contractual obligations, kind of multiple litigations happen. So how to mitigate this? Now law has framed a step-by-step framework. We are not getting into it. We are just going to discuss what is the framework. So section 7 is the revocation of registration and section 8 is obligation of authority consequence upon lapse or for revocation of registration. So there has to be a way out. If projects are stalled, the buyers do not possess the necessary skills. They do not have the necessary knowledge of how to complete projects. However, the law has ensured that some kind of provision has been built in so that such a possibility can be availed of. That is what is section 7, I think essentially section 7.3 and section 8. So what it allows for formation of legally constituted association of LOTs, which means it takes care that legal clarity is given for any person who wants to move ahead with respect to a stalled project. Then yes, you can file a complaint with RERA. You need to claim relief to allow the association of LOTs to take over. So a step-by-step process has been given. RERA will also try to understand the willingness of existing developer to complete the project. It's not as if all the doors are closed. Sometimes it may be in the best interest of everybody concerned to allow the developer one final chance. Here the developer will have to make commitments which probably are all doable and achievable, or something which he has not been able to do in the past, but he demonstrates good faith that he will do it. Yes, in that case, the opportunity is available to the developer to step in again. And then, in case he fails, there can be any scheme for completion of the project. So, RERA will hear out the association of the LOTs. First right of refusal always rests with the association of the LOTs. Here, a legal right has been given with respect to first right of refusal. So, any promoter who has been constantly going back on his promises, if he thinks that at this stage also, this is something very similar to what happened in IBC and how the Supreme Court decided on it, that existing promoters who have repeatedly failed cannot be given a chance. Something very similar is over here. And then again, it goes one more level. Yes, that the project has to be, detailed scheme has to be proposed, clarity has to be obtained as to how the project will be completed, and upon satisfaction, RERA will approve it. Now, there are 3 or 4 examples which has ensured that they have successfully ensured that the project has been executed by the association of LOTs. This is just one of the projects, DSK Sadafuli, I think it was in Pune. They went through various strong points, or whatever we call as in management jargon as SWOT analysis, with respect to legal, with respect to financial, with respect to technical, and how they were allowed to go ahead. Because end of the day, there had to be decent money within the project which was to be receivable to ensure completion of the project. It was a cash flow management, it was a P&L management, both brought in together along with the skills and knowledge of the executing agencies. Then yes, one of the important factors was that project should have been in advanced stage of completion. Somebody said that it should be 90% complete, only 10% should be left behind. It is basically essentially what we call the last mile completion of the project. Net worth positive, we discussed the cash flow and the P&L aspect of it. And yes, there should be a confidence building mechanism. I think one of the areas of advisory services would probably be that CAs would be empaneled, or all the professionals would be empaneled to carry forward stalled projects. Here is why I keep on insisting that please acquire domain knowledge. This will be an area which may open up in the next 2 or 3 years. Chartered accountants, again, by virtue of their analytical skills with respect to money, are better placed. Yes, they have to understand how legal processes work. They have to understand how architects and engineers also deal with the competent authority. So please acquire this knowledge. I'm sure that this is going to be one area which is going to open up for chartered accountants in future. then yes, again the mechanism said that if this also fails, then the government will take over. Honestly speaking, I do not see government taking over these obligations. They neither have the willingness, nor probably the skill set, nor probably the inclination to get into this, because it will be a huge learning curve. By nature, government agencies and their officers are used to dealing in a certain way. To bring that kind of skills into these projects, I would rather keep my fingers crossed. Now, again, what are the other legal recourses available? So these are just a few acts which are there. Key amongst this is the Consumer Protection Act and the Insolvency and Bankruptcy Code. Now, look, there will be a lot of intersection over the next 2 years between all these acts. Who has the first right? Which law will be first? Committee of creditors, financial creditors, who is defined as what? This will all settle down over a period of time. Since Supreme Court is already dealing with the Amrapali cases, which in terms of number of units is very, very large, I think whatever will come up will start getting applied to all the projects on a proportionate scale. So let's wait and see what kind of doors open up, what kind of roadmap comes out of all these activities, and whether there is success or whether there is failure. I think that's all I want to discuss. Probably I want to help add on one thing, that look, so many projects where the project registration date has expired and there has been no extension applied for either by the promoter or granted by the authority would be very large in number. This opportunity is going to be for real. So please, everybody, keep an eye on how this shapes up going forward. Again, thank you very much. I think this is all I wanted to say.
Yeah. I thank CA Kaushik Sampat for the deliberation of the stall projects. He had a marathon run today, we can say, and filling in for Sunil Naik sir also because he was busy with some professional engagements, and he had gone through the presentation of Sunil sir and why projects are stalled. He gave a background why projects are stalled and what can be done for there, and why, and success stories that the projects are getting revived. So I also thank all the participants for joining in large number and making this a very good session. So I, on behalf of WRC of ICI, propose a very hearty vote of thanks to CA Kaushik Sampat sir, and with a lot of applause. And tomorrow there will be a session, continuing session at 5 o'clock, and it will be the details will already be sent to you via email. I thank WRC of ICI giving the opportunity to coordinate today's session. I also thank all the participants joining today for today's session. And we hope that it has been a very knowledgeable session from all the speakers today. So I think and with this we should close the session. Request to close the session. Thank you. See you all tomorrow.